Mr. Deputy Speaker.
Order. Questions for oral answer. Ms. Carrie Tan.
Mr. Speaker, the Ministry is unable to provide the specific number of cases where one spouse falsely alleges during the divorce process that the other spouse has abused the child in order to prevent the other spouse from obtaining custody, care and control, all access to the child, as the Family Justice Courts does not have such data available. Nonetheless, furnishing false information to a public servant, which includes a judge or officer of a court of justice, whether or not as part of the divorce process, is an offence under the Penal Code. If convicted, the individual will be liable to a fine and/or a term of imprisonment. Over the last 3 years, from 2019 to 2021, an average of approximately 80 persons were convicted annually of such an offence of furnishing false information, but this is not limited to the context of child abuse allegations in divorce proceedings. Thank you.
Ms. Carrie Tan.
Hi, Speaker. Dear Deputy Speaker, I thank MOS for her answer. And I think I want to set a context for my SQs, which is that it's not uncommon for us to come across cases where post-divorce or actually during divorce, individuals try to find reasons to deny or prevent access or custody of the other of the ex-spouse from the children. And in the spirit of MSF's latest efforts to introduce restorative justice into divorce proceedings, whether MSF currently has or will include emphasis in the divorce counselling process to stress to parents that depriving children of access to their parents can actually have detrimental effects on their well-being, and to stress the importance that collaborative co-parenting is necessary for the children's well-being. And I ask this because I have come across several attempts by citizens or residents to seek advice from me, from knowing that I champion women's rights, to ask for advice on how they can prevent custody of their ex-husbands to their children. And personally, those could be stemming from biases or fears that the individual may have. So I feel that MSF can do something to help citizens understand the importance of having both parents in a child's life despite divorce. Yeah, thank you.
I thank the member for her question. Indeed, at the recent second reading of the Women's Charter, I had shared about how we will be introducing a range of measures to enforce child access, and that includes allowing the court to order the care and control parent to grant the access parent additional access to the child to make up for the access denied. B, the care and control parent to compensate the access parent for expenses incurred as a result of the breach of order. C, both parties and the child or any of them to attend counselling, mediation, therapeutic or educational programs or family support programs. D, the care and control parent to enter into a bond to ensure future compliance with the order. And E, as a last resort, imprisonment or a fine for the care and control parent. But that said, I entirely agree with you that what's important is that we try to encourage co-parenting behaviors between the divorced spouses, because at the end of the day, there is a child at the center of this, and we do not want too acrimonious a relationship between the ex-spouses, because it will be to the detriment of the child. So specifically on this, we have set up 5 FEM at FSCs, and there will be a further 5 more FEM at FSCs, which will be set up by the end of 2022. And they bring together existing marriage and divorce support programs and services. And we have also introduced a new family counseling service, which includes parenting support and which helps to look at parent and child issues. The work at the FEM at FSCs is also complemented by the work of the DSSAs. The DSSAs, together with the FEM FSCs, their programs are actually delivered by specialized counselors and the social workers, whose aim is to help divorcing parents understand the impact of their divorce on their children, and also to work out their differences so that they can parent effectively. So what I mentioned earlier on the legal measures, we hope that that is a last resort. At the end of the day, we want to restore the relationship, hopefully, between the divorced ex-spouses so that they can co-parent effectively for the best interests of the child. Thank you.
Ms. Carrie Tan? No? Ms. Hanny So?
Thank you, Mr. Deputy Speaker. This question is in relation to, I echo what Ms. Carrie Tan have said in relation to restoring the family relationships despite the breakdown of the parental marriage. This is in relation to asking, because currently it's made compulsory for parents prior to filing of the divorce to undergo a counseling sessions. My suggestions is to MSF whether to consider, because children are often being torn and feeling very difficult in making decisions when it comes to choosing which parents to follow as a result of the parents' breakdown, whether it may be making it helpful for it to be a compulsory sessions for the children to also undergo a series of counseling sessions while the parents at the same time go for the counseling and mediation sessions at the same time.
I thank the member for her follow-up question. Earlier I mentioned that the court can order the parties, the divorced spouses and the child, or any of them, to attend counseling, mediation, therapeutic or educational programs or family support programs. So the court can order this. But we have stopped short of making it mandatory across, like the MPP, which I had talked about at the second reading of the Women's Charter. And that is because we recognize that there can be different circumstances that affect families. And we don't want a situation whereby by making certain programs compulsory, we actually add on to the stress that the child or the divorced spouses may already be experiencing. So we have adopted a balanced approach in that should there be persistent transgressions from one spouse in denying access to the other spouse, then the court can order such counseling and mediation programs. But we stop short of making it compulsory because we recognize that there may be different, unique circumstances facing each family. Thank you.